You would think the head of the agency tasked with regulating the entire firearms industry
to end some of the restrictions, which some people call restrictions, I call safeguards.
After Charleston, after Orlando, after Las Vegas, after Parkland, nothing has been done.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace,
to go to school, to a grocery store, to a church, without being shot and killed.
The Second Amendment to the United States Constitution, Mr. President, as you well know.
Maryland's attack weapons ban. Before a federal appeals court can make a decision in the protracted case, armed rights organizations have asked the U.S. Supreme Court to consider their challenge to Maryland's ban on attack weapons, such as the semi-auto AR-15 rifle. On Thursday, they requested review by the Supreme Court after the 4th U.S. Circuit Court of Appeals, located in Richmond, Virginia, made the unusual decision last month to permit all 14 of its sitting judges to hear the case before a 3-judge panel that had heard arguments in December 2022 could make a decision. In a petition, 3 armed rights organizations referred to the 4th Circuit's action as the most brazen illustration of how appeals courts are failing to heed the clear teaching of this court's precedents about the Second Amendment's guarantee of the freedom to keep and bear weapons. According to a statement from the Second Amendment Foundation's executive director, Adam Crott, the 4th Circuit's choice to hear the case en banc prior to the panel's judgment seems to imply the court desired to take this case from a panel with which it disagreed. Following a historic Supreme Court decision on armed rights in 2022, the group contended, along with the Firearms Policy Coalition and the Citizens Committee for the Right to Keep and Bear Arms, that laws prohibiting semi-auto rifles, such as Maryland's, are unconstitutional. The court's 6-3 conservative majority in that decision, New York State Rifle and Pistol Association versus Bruin, acknowledged for the first time that a person's right to carry an arm in public for self-defense is protected by the Second Amendment. A new standard for evaluating armed regulations was also established, stating that limitations have to be consistent with this nation's historical tradition of armed regulation. The Armed Rights Organization, a number of people, and a supplier of arms stated that the Supreme Court should now determine whether law-abiding citizens might legally own semi-auto rifles for self-defense in light of that decision. According to their petition, attack weapons are similarly prohibited in 9 other states. In decades afterward, Democratic lawmakers who support armed control laws have failed to renew the 10-year federal attack weapons prohibition, which expired in 2004. The group's attorney, led by David Thompson of Cooper and Kirk, claimed in the petition that the court should step in now to make clear once and for all that the most popular rifles in the history of the nation are protected by the Second Amendment. A request for comment on Friday was met with no response from the Democratic Attorney General of Maryland, Anthony Brown's representatives. However, he has stated that the restriction is required to safeguard the population against armed crime.
You would think the head of the agency tasked with regulating the entire firearms industry
to end some of the restrictions, which some people call restrictions, I call safeguards.
After Charleston, after Orlando, after Las Vegas, after Parkland, nothing has been done.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
Brewing legal challenges. The Supreme Court is currently considering a lawsuit that could potentially lift the ban on attack weapons in all 10 states, plus the District of Columbia. This case was previously heard in the Bruin case, where the Supreme Court granted certiorari, indicating their intent to recognize and take up the case. The court overturned the 4th Circuit's decision that upheld attack weapons bans and sent the case back to the 4th Circuit, instructing them to re-evaluate it based on the guidelines established in the Bruin decision. The Bruin decision emphasizes that the evaluation of attack weapons bans should not rely on intermediate scrutiny but rather on considerations of text, history, and tradition. This marks a significant development in the ongoing legal discourse around the Second Amendment and armed control. The lawsuit challenging Maryland's attack weapons ban, known as the Bianchi versus Maryland case, has been brought before the Supreme Court by the Second Amendment Foundation and the Arms Policy Coalition. The case originated after the first attack weapon ban case, KBY versus Hogan, where the district court declared the ban unconstitutional. The Fourth Circuit intervened and overturned the decision, arguing that since attack weapons are highly capable of military use, additional restrictions can be imposed on them without violating the Second Amendment.
Your right to own a gun can also be restricted.
To go to school, to a grocery store, to a church, without being shot and killed.
The Second Amendment to the United States Constitution, Mr. President, as you well know.
While this bill doesn't do everything I want, it does include actions I've long called for that are going to save lives.
Second Amendment Foundation. After the initial dismissal by the district court, citing the Colby case as precedent that attack weapons are not protected by the Second Amendment, the case was appealed. The Fourth Circuit upheld the dismissal, referencing the Colby decision. However, following the brewing decision by the Supreme Court, which emphasized a re-evaluation based on text, history, and tradition rather than intermediate scrutiny, the case was granted certiorari and remanded back to the Fourth Circuit. Surprisingly, the three-judge panel at the Fourth Circuit took 13 months without rendering a decision on the case. Now, the Fourth Circuit en banc panel has taken the case, mirroring delays seen in the Ninth Circuit in California regarding their attack weapon ban and magazine ban. This situation echoes similar challenges reported over the years in the Seventh Circuit in Illinois with their ban. The Second Amendment Foundation is raising concerns, pointing out that the Supreme Court emphasized the importance of rehearing the case based on the brewing decision. However, the Fourth Circuit has yet to comply. This issue is now back before the Supreme Court, and all 10 states plus the District of Columbia with an attack weapon ban are urged to pay attention. The Speaker lists the states, emphasizing the widespread implications of this legal challenge.
Thank you, Mr. Chairman. Real quick, I find it interesting that my colleagues have no problem with the ATF going outside its boundaries.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
President Biden went on to point out that states have their own ability to make state-by-state gun legislation.
That's not for us to regulate. If somebody we wrote the rule to make it easy to comply with.
Attack weapon bans. The Second Amendment Foundation has posed a crucial question to the Supreme Court. Does the Constitution allow the government to prohibit law-abiding citizens from using commonly used semi-auto rifles for legal self-defense purposes? This inquiry signals a call to cut through the legal complexities and settle the matter definitively. In their petition, the Foundation highlights the historical significance of rifles in American culture, symbolizing power during the fight for independence and serving as a companion and protector for westward pioneers. The modern embodiment of this iconic arm is the AR-15 style rifle, a semi-auto weapon widely popular for its accuracy, ease of use, and ergonomic design. Despite being the highest-selling rifles in the nation's history and owned by millions of Americans, approximately 20% of all arms sales over a decade, some states, such as Maryland, have sought to ban semi-auto rifles. The Foundation argues that these bans are blatantly unconstitutional, referencing the precedent set by the Heller decision.
Turns law-abiding gun owners into felons is a result of unelected bureaucrats simply enacting a new regulation.
Gun laws in 40 of these states are still in place based on the decision. Not good enough.
When attached to a firearm, does not convert that weapon to be fired from the shoulder.
He pointed out a Supreme Court ruling back in 2008 that said that the Second Amendment is not absolute.
A call for constitutional clarity. The evident unconstitutionality of semi-auto rifle bans is underscored by recent attempts to circumvent the clear implications of the Heller case. In Heller, the court established that the widespread use of hard arms for legitimate purposes is sufficient to warrant constitutional protection. The decision explicitly rejected the notion that colonial restrictions on dangerous and unusual weapons could justify laws limiting the use of contemporary and commonly used arms. Despite the clarity provided by Heller, subsequent legal developments have raised concerns. Illinois, for example, has maintained a ban on modern semi-auto rifles, and the Seventh Circuit interpretation in the Friedman case seemingly aligns with pre-Bruin rulings of the Fourth Circuit. This divergence from the principles laid out in Heller and Bruin raises concerns about the consistent application of Second Amendment protections. The Ninth Circuit, too, has shown a tendency to stay injunctions and delay cases related to arms restrictions, as seen in California's magazine capacity law. A similar approach is observed in holding a case challenging California's ban on modern semi-auto rifles until the resolution of another case, Duncan.
The president calling on Congress to pass red flag and safe storage laws and strengthen background checks.
This rule redefined firearms with stabilizing braces as short-barreled rifles.
Disappointed in the Supreme Court gun decision. There is one little bit of solace.
While a firearm so equipped would still be regulated by the Gun Control Act,
in the case challenging Maryland's ban on semi-auto rifles, the Fourth Circuit initially affirmed the dismissal based on the Colby precedent. However, the court later granted rehearing en banc, indicating potential dissatisfaction with the panel's intended outcome. This series of events highlights the need for the Supreme Court's intervention to uphold fundamental rights. The petition urges the Supreme Court to establish unequivocally that bans on commonly possessed arms by law-abiding citizens are constitutionally impermissible. The argument stresses that modern semi-auto rifles, like the AR-15, have been traditionally accepted as lawful possessions owned by millions of Americans for self-defense and other legitimate purposes. That's all for this video, folks. See you next time.